Good morning, everyone. My name is Larry Cantor. I want to welcome you to our web conference this morning. And we are really pleased to be able to provide this web conference in light of the changes that are taking place as a result of the COVID shutdown. As many of you are aware, things have changed in court. Most proceedings are now remote. There are a few in-person trials, as I understand it, but most proceedings are remote. And we thought that this topic would be something that all of us could benefit from. So I want to introduce the panel. I am the moderator, so these folks are really the people with the information. I encourage you to ask questions throughout the discussion. I think you're going to hear some things that you might be surprised about. I certainly learned a lot just planning this conference. So first off, I want to introduce Alex Walther. He is a CPA, and Alex and I have worked together for a number of years. It's been a long time, actually, going back 10 years, I think, Alex. And Alex has a great deal of experience in the forensic accounting world. And Alex, why don't you talk a little bit about your background?
Sure. Thanks, Larry. Hi, everyone. For those of y'all that don't know me, like Larry said, I'm Alex Walther. I'm a senior vice president with BBA Group. And primarily my focus is on economic damages, as well as more of the accounting heavy type cases with the traditional forensic accounting, fraud investigations, that type of thing. I've been doing this about 13 years. I'm chair of the BBFLS committee. And one thing just to point out while I have the mic here for 30 seconds is this is hopefully going to be the first of many conferences that we're going to do, since we weren't able to have our traditional in-person forensic and valuation conference. So this is the first of hopefully many. And I know, similar to Larry, working with our other two speakers, learned quite a bit, and I'm looking forward to having a good discussion on the webinar today.
Thank you, Alex. So I want to now go to the people who are really going to provide all the information that you've been waiting to hear about. I want to introduce David Janinder of Baker Botts. David is a seasoned, does that mean old? No, it doesn't mean old, right, David? A seasoned litigator who has tremendous experience in this area in doing remote type testimony cases, or in court and in depositions and that sort of thing. So David, go ahead and tell everyone about yourself.
Thanks, Larry, and thanks to the TXCPA for having us. I think seasoned just means my hair is salt and pepper. But I will tell you this, I don't know if a tremendous amount of experience is what I have. I have a lot in the last 7 months since we've gone into shutdown, and that's one of the things that we'll obviously be talking about. Larry is absolutely right that that's the way everyone is kind of moving. I'm a trial lawyer. I've been doing this for 26 years, civil trial work, the whole gamut. I joke that we're all becoming energy and technology lawyers, but I do patent work, I do private equity work, general commercial work, energy work, you name it, we've probably done it. I've probably done it in the last 20, 25, 26 years. So it's, and I actually have some experience with these remote depositions and testimony dating back 20 years, which we'll talk about as well, because it's very different now. But thanks again for having us, and look forward to talking about this. This really is some fun stuff to discuss.
Thanks, David. And then the other member of our esteemed panel is Sam Hardy from the law firm of Lynn Pinker. Lynn Pinker is a firm that does, I believe, only litigation. It's a very well-respected firm. And it is a pleasure to have Sam, because I think he's actually written articles about this topic in the past. So Sam, would you tell the panel or tell the audience a bit about yourself?
Yeah, sure. Thanks, Larry. Sam Hardy, partner at Lynn Pinker Hirsch & Schwegman. And as Larry said, we are a commercial litigation boutique. All we do is litigation. I've been practicing for 12 years, 10 years here at the firm. And we have, much like David said, become very quick crash course experts in remote depositions, which have a lot of things have remained the same and some things are very different. And I've not done an actual expert deposition yet remotely. I've done multiple fact witness depositions and evidentiary hearings in the last 7 months. And but much of what, or all of what, I think we've experienced translates directly into the expert arena as well. And I very much appreciate being here.
Well, and guys, we are so happy to have both of you. I think it's wonderful that you could carve out the time to do this. So let's just jump right into really the first topic. And it's something that I really wasn't aware of as a CPA. And that is, it turns out the rules for remote testimony and testimony via web conference have been around for quite a while. I didn't know that. It's just they were never really needed or used. And the COVID era forced us into being able to experience the world of Zoom type testimony. So with that, I'm going to turn it over to Sam and David to talk about the history of giving testimony remotely. Sam, you want to lead it off?
Yeah, sure. So in your handouts, I've provided the deposition rule for Texas state courts and the rule for federal courts. And in both of those rules, which obviously predated COVID, they both contemplate remote depositions being allowed. And in Texas, they are allowed. The only stipulation in the rule, or the only wrinkle in the rule that affects Zoom depositions, is that the rule states that the court reporter, the examining officer, is supposed to be in the same room as the witness. The federal rule, which also contemplates remote depositions, allows it by stipulation or order of the court. And so remote depositions have been with us for a long time. I didn't go back and look to see when both of those rules were amended to add it, but as David, just like David, I'm sure I had prior experience with remote depositions on a rare occasion, almost all by phone, when it was a third party who was perhaps, out of state, maybe 30 minutes or an hour or two. You just needed to prove up some documents. That's sort of what the world of remote depositions looked like. And now, of course, they've turned into, remote depositions have replaced in-person depositions, it seems, universally. And with regards to the Texas state rules, the Supreme Court of Texas issued an emergency order, which is also in your materials as just for illustrative purposes, that suspended the requirement that the examining officer be in the same room, and therefore, essentially a remote deposition is treated exactly like an in-person deposition. You have no objection to it, can't make an evidentiary objection or a procedural objection. They're going to be admissible in court, the transcript and the video, as if they were taken, under in-person circumstances. And the federal rule, we can talk about in a little bit too. That's been handled a little bit differently in my practice, and I'll be interested to hear what David says. Parties have typically gone to a much more stipulated, express, and detailed order that they agree upon. There's another example of one of those in one of my cases that's in the materials. That is a much more fulsome sort of expression, which is typical of federal court. It's a little bit more over-lawyered perhaps than state court practices. But in both fora, remote depositions have always been allowed and are now being used for the first time and much more commonly and much more universally.
That's absolutely right. And my take on this, as I mentioned this earlier when I introduced myself. My only experience with a remote deposition dates back to about 2000, 2001, where we had an expert witness who was testifying from Australia, economic damages expert. And we got the court to, over the other side's objection, to require them to take that deposition remotely so he wouldn't have to travel halfway across the world, get accustomed to local time for a 7-hour deposition and then fly halfway around the world. I got to tell you, it was an unmitigated disaster. The technology was not good. The documents could not be used effectively. They did not send them over. They were trying to use them real time. with I'd like to say I planned that, but I didn't. When you're doing these kinds of things, turn off your phone and notifications. We actually talked about that. But the old time deposition, it didn't work. They're trying to use an Elmo kind of device to broadcast documents across the world, and it was my witness, so it actually worked out okay because it wasn't a very effective deposition. You fast forward to 2020, we had a witness who was in London. And instead of coming again over to the U.S. for this was a 3-hour deposition, the other side agreed he could do it by Zoom, and it worked beautifully. I mean, the technology it's just night and day. And we were able to get into a separate chat room on breaks, and the documents could be chatted instantaneously back and forth. And on Sam's point about the agreements, I really think there's a lot of flexibility there. Lawyers tend to be distrustful of their opponents and think they're going to try and take some kind of advantage if they're not in the room. And we were able to come up with an agreement in this one matter where the witness was in an office by themselves. So the lawyers couldn't be hand signaling or passing notes that we wouldn't see on camera. Another alternative to that is to have another camera in the room that has a wide view of the entire room so you can see what's going on. But we didn't need to do that. They readily agreed. Yeah, we'll have the witness in a separate room. And it's not foolproof. Obviously, you can have a device, a phone, or an iPad, and messages can come in that way. But it's pretty good, and you got to have a little bit of trust going forward. But yeah, these are not new. It's just that they weren't used. There was such a huge presumption against using them, and a bias really against using them. People thought they weren't effective. People thought you weren't doing your job if you could force the other side to bring a witness, and you instead decided to do it remotely, that you weren't going to get in their face and beat them up and do your job. And I think that we have now overcome that kind of practical obstacle. And then there was technology. I'm just going to call it technology ignorance. I didn't realize how good the technology had become and how easy and effective it was to set these things up on very short notice. So whereas before, I never would have considered doing a remote deposition of a semi-important witness, not a key witness, but a semi-important witness by Zoom, I'm not going to hesitate in the future to do it. Or a third-party witness who I think is not going to be all that controversial witness, I'm not going to get on a plane and travel to wherever they may be if I can do it by Zoom. Larry, back to you.
That is it's interesting because as an expert, I've never really participated in anything remote prior to COVID. So this is all new, and because it's new, I think it would be helpful for you all to give us some information about how to plan for participating in a remote deposition, remote testimony, and observing an opposing expert remotely and being able to do it in an effective way. What do you need to know before you actually walk in or sign in to the meeting?
Why don't I start on this one, then turn it back over to Sam. The list is too long to go over, even in an hour and a half, of all the different categories of information. You need to be thinking about how you're presenting. Obviously, you want to be dressed as if you're live. You want to think about what your background looks like. There are virtual backgrounds that people use. I tend to think those are kind of fake looking. I want my experts to seem like professors. So if you have some kind of a scholarly background with books, Sam, you saw before, has all these books behind him. That's a great background, in my view, for an expert witness to be testifying with, or a whiteboard or something that makes you look like you're a teacher, because that's what we obviously want our CPA experts to come across as. You need to be prepared for the strangeness of the process, especially testimony. You're not going to be able to get as many nonverbal cues from your audience. You're not going to be able to see the jury probably as well as you might if you're testifying live in court. You're not going to be able to get the responses of the judge or even your lawyer as clearly as if you were sitting in the same room. There's just a lot of you're kind of isolated. So just be prepared for that. And then remember who your audience is. When you're talking into a computer camera, it's easy to forget. I can't see any of the people who are watching us. I'm hoping there's a whole bunch of you. But it's hard to have that kind of any kind of connection with your audience when you can't really see them. And in a deposition, it's really hard to be thinking about that real time. As far as preparation, I think you do the same kind of preparation you do for real testimony. If you have an expert report with a support binder, I would have that with you in the room. You can have support materials. It's very hard for the other side to complain about that. It does make the process go a little bit more smoothly because typically in a deposition, the lawyers are going to ask you, what is it you got with you? And they'll want to take a look at it. It's much harder for them to do remotely. And then the only other thing I would caution you about is humor. We all tend to throw in a joke here or there. Humor is very difficult remotely because you can't get any feedback and you're not sure how it's going over. Doesn't mean don't make an obvious, lighthearted comment, but I would be just careful about getting off script and off topic because it's hard to see how that's going over with your audience. Sam?
Yeah, so I think those are all excellent points, David, and some concrete things that I think are have to be considered ahead of time is, if you're talking about a deposition, working with the attorney you're collaborating with, has there been a negotiated protocol ahead of time? If there hasn't been one, and then what is that? And learning that. If there hasn't been one, then thinking about and getting ahead of issues as they're going to come up. So just to give you some examples of horror stories or sort of like lessons learned, one of my favorite sayings is from Abraham Lincoln or from Benjamin Franklin, which is, experience is the harshest of all teachers, but a fool will have no other. And I've learned a lot of hard lessons over the last 7 months in remote depositions. So you have to think about things such as, where are you going to place your camera? What room are you going to use? Are you at home or are you in the office? People will tell you, place the camera not on the desk, so you're being angled up. Place it on mine is on a box, for example, in my office. Do you have sufficient bandwidth? Have you tested the bandwidth? Does your laptop or your desktop camera, does it have sufficient resolution? Is the microphone sufficient? Or should you have a separate dial-in line for your phone? Are you going to use a landline? You can use a cell phone. Okay, obviously landline's better for both internet connection and phone connection. Desktops are probably sturdier and better than laptops. David's got a setup where there's a separate camera, and he's got sort of, I guess, a studio sort of a setup or potential kind of thing. And by the way, talking about backgrounds, I've got a little mini studio in my office I've set up with a podium and a background. This is just at my desk. And while I very much appreciate the compliment of my background, I'm noticing that there are problems with it. For example, I have scotch up here in the corner. I have my children's art here. And then I have, a Chevelle SS 1968, book back there that I was looking at because I like muscle cars, right? So these are all distracting things that, the examiner, or more specifically the jury, may be focusing on and not focusing on you. These all have to be thought about ahead of time. And practice makes perfect. I would encourage you, if you're giving any kind of remote testimony, to make sure that you bring it up. If the lawyer doesn't bring it up, I'd like to practice. I'd like to see. I'd like to have like a mock dry run for 5 or 10 minutes to make sure my setup is going to work. And then, some obvious things that sound obvious, but are not going to be obvious until they happen to you. So if you're sharing screens, for example, make sure you've turned off any notifications that you have so that emails don't pop up on your screen. So people start sending you emails, and then everyone in the world is going to see the notification at the top of your screen if you have Outlook like I do. And then the subject matter and the sender are going to be right there, and they're going to be recorded, and that'll be part of the record in the case, which obviously is not anything that you want. Dings for email, or alerts, or calendar alerts, notifications, right? That all is sound that's going to appear in the record, and may interfere with your testimony or come at a key case. I took a deposition on Wednesday. The fact witness was in Arizona. He was taking it in his home office, and we were probably interrupted. And it wasn't really his fault. I don't know what to do about it. There wasn't anything I could do about it, but probably 5 or 6 times during the course of that deposition, his 8-year-old son came into the room to get his kickboxing equipment or just walk around, wander around like kids do, right? And, it was a humorous moment. I will tell you, I was pressing this witness pretty hard, and I was really cross-examining him on some really incredible, statements that lack credibility. And in one key moment, his kid walks in, and it's this sort of lighthearted, humanizing moment for him, which I did not care for because I really wanted to make him look like he was not being credible. And I was, for my client's purposes, and pressing him, and then it sort of took that whole moment out. These are all sort of minor issues, but collectively they really alter the experience that you give as a deposition or as you give as a witness. And you obviously, as an expert, don't want anything to detract from your authoritativeness or distract from the actual opinion that you're giving. So the technical aspects of it, the where you're going to be, the physical situation, all of the things that may come up that won't be apparent to you until they actually happen to you have to be thought about and discussed, with counsel.
Let me add one more thing. Sam reminded me. It's not a bad idea to have a backup. So if you're planning on doing it through your laptop with your setup, it's not a bad idea to have an iPad or a phone or something just in case you hit some kind of technology problem with your main device. I've had that. We've all had it happen where someone says, "I can't get into the meeting. Let me dial in." Same kind of thing with these video appearances. It's not ideal to have to be staring into an iPad rather than one of these nice setups, but it's better than not being able to do it at all, especially for live testimony. The other thing Larry had asked about that I forgot to mention was how best to assist your lawyer client when the opposing expert is being deposed or somebody else, the fact witness, is being deposed, and you need to help them. Obviously, you can sit in on the deposition as if it was live. Virtually every court will let experts do that. I've done this. I've actually done it with Larry. The best way to really communicate about what's going on in the deposition is either through text or through a phone call at breaks. You can set up these separate chat rooms in Zoom, and I'm sure they're secure. And I'm sure that if you're the one hosting the deposition, it is going to be secure. I always feel better turning off the volume, turning off the camera, picking up the phone, and having a conversation outside the room with my expert, who's going to help me get through the deposition.
Yeah, I'll just add. I'm sorry, Larry. I was just going to add one thing. Yeah, hot mic moments are real. And you want to avoid those as much as possible. And I follow that same practice. We use something we haven't talked about, and maybe this anticipates this prematurely, but what we have sort of defaulted to is using an actual service that is designed to do remote depositions, as opposed to, we started off trying to sort of cobble it together through Zoom, our own Zoom accounts. But what we've been using in my cases is a service, and often either defendants and plaintiffs will want to agree to the service or agree to a set of services, or, as you'll see in the order, the order in that antitrust case that was entered in the Eastern District, it's in your materials, minimum requirements were set forth, and then you can use whatever service satisfies that. The service takes a lot of the technological problems out of it and takes it out of lawyers' hands, which is where they do not need to be. But despite all that, I follow David's practice too. I mute when we are breaks, or if anything's happening, I mute the camera. I blind the camera, mute the microphone, and then step out of the room, and then have conversations with my colleagues or whomever as appropriate. Out of the room, just because again, like, it's all recorded, and once it happens, you can't unring the bell, and a stitch in time saves nine.
Alex, to expand on this, sorry, Larry.
I was going to suggest, Alex, that from a CPA's perspective, who's given depositions, who's given testimony live, can you address some of the questions, I guess, for Sam and David about how to plan for the new issues that arise now with giving a deposition? So, for example, in my experience, I've always had a binder of documents in front of me at the deposition, and it's usually PDF copies of something that I'm referring to, or the opposing counsel is referring to. Now we have a different ability. We can actually pull it up on a live Excel model or a live Word model. Can you go in and talk about what some of the things that you fear and want to plan for in that new world?
Sure. Well, I think it all comes back to planning, and my experience has been a little bit different than Larry's. The first time I was deposed, this was probably 5 or 6 years ago. The attorney, we actually had the equipment in the room that they had the capability to put a live Excel model up on the screen that we were using. So my experience was even when we weren't in this remote deposition world, that capability was there for an attorney that was comfortable using it. Now, I think that in the environment we find ourselves in, that's going to become more the norm. We're going to see more and more attorneys becoming comfortable with that type of approach. And for some experts who maybe may not be as comfortable doing live adjustments to a model, you may want to take a step back and think to yourself, what are the implications of doing these live adjustments? Because typically when we go and do our analyses, we're spending countless number of hours putting it into developing this model and making these on-the-spot adjustments. In a deposition, you may not pick up on all the little nuances that these small adjustments may make, but some things may be straightforward, like coming up with a discount rate and making a 1% change and what impact that has on the overall model. That might be a bit more straightforward, but some of our models can get really complex, and if we're changing one particular input to see how what might occur, that could be very dangerous to do on the fly, especially if you as the expert may not know what that's going to do to your model. So you may want to think, what is a potential, it may not be the best way to say it, but what's the potential canned response that you may have to disclaim or say, why this, I can change this input, but that's not really my opinion. My opinion was in fact what it was originally. It's just that type of thing you need to probably think about a bit more and prep for.
Yeah, and that Alex is absolutely right. We've used native versions of exhibits, and when the other side has produced a native Excel of their model, we use those in depositions, going back in time as long as I can remember. And Alex's advice is exactly right. You can always say, if you make that change, this is the result, but I'm not sure that's reliable. We put a lot of time and effort into thinking about every input into this model. I'd have to give it some thought to answer any further questions on it. But if you make that change, that is the number it spits out. Which is very simple and factual way of dealing with that. I do agree that we're going to see more use of these native files in the remote setting as people just get more comfortable and the lawyers get more comfortable driving their own exhibits. They're not just going into a room with a box full of paper copies. They are sitting at a computer where these files actually reside. In order to do an effective examination with an Excel, you've got to plan for it. You got to get a laptop, you got to get a screen, you've got to get all the stuff that not every lawyer is comfortable doing. And for better or for worse, a lot more lawyers are going to be comfortable doing that in this new world.
Yeah, I totally echo that. I mean, one of the things I had seen, I've tried to use Excel spreadsheets with experts, and I've seen people use Excel spreadsheets with experts. But getting the sheet on the camera with the expert and joint attention in an in-person deposition is very difficult, right? There's a lot of technical hoops you got to jump through. And so the examination ends up not being particularly useful, at least as for trial or impeachment purposes. That's completely changed with Zoom, right? Because you can share the screen. And so you can have joint attention on the screen, and the video that plays to the jury or the court can be split. So I can have my expert or my fact witness. I've already done this so far. I mean, I've created videos this way already. So where I've got the fact witness here, and then I've got the split screen with the document there, or a live Excel spreadsheet. And, we're having joint attention on this document, which means the jury's having joint attention on this document. And that can be a very powerful way to examine an expert, particularly on assumptions or inputs or formulae in a live spreadsheet. And one of the things I would encourage you to do if you find yourself, you're going to be deposed and this is going to be an issue, is have a discussion with the attorney about how those exhibits are going to be handled. I mean, in an ideal world, you probably want to have the ability to control the spreadsheet yourself, or at least to control a copy of it yourself and not be completely captive to whatever the examining attorney is showing you, right? And you probably want to have your attorney have the ability to also have that document or that file and be able to use it. So we use a service called Lexitas. That's kind of, I think David uses the same one. It's a very robust platform, but I can put a document on the screen and I can show it to the witness, but the witness has the ability to download that document once I identify it and can open it up in a separate window. So, to the extent you may not trust attorneys in their examination, or at least or being generous, their understanding of the work that you've done, you probably do want to have the ability to have that, so you can say, no, it's incorrect. You're looking at column K, you got to look at column Q as well, something like that. If you can't really do that, if you don't have the access to the document and the attorney doesn't give it to you, you're sort of left with, well, I think it's something different, or maybe that's not the case. I'm not really sure because I can't see it, right? Which is far less effective testimony.
So
Larry, can I jump in just because I want to go back to one thing on the sort of the reverse side. We're helping the attorneys take a deposition, and this was something that both David and Sam hit on around being able to chat or text or call on breaks. One word of caution I wanted to throw in on that is on Zoom. There's a lot of settings on Zoom, and if you aren't the one that set up that Zoom conference, you don't know how that Zoom conference was set up. And if you're using the internal chat box, there are situations where you may think that you're using that chat box and sending something directly to the attorney you're working with. If the Zoom conference wasn't set up appropriately, there's a chance that if it's being recorded, when the recording stops, all those private chats can get attached to the recording itself. So this is something I've actually seen. Granted, it wasn't in a deposition, thankfully, but it was just a regular presentation that was being recorded. That all the private chat that was going back and forth became part of the sort of the public recording and was viewable by everyone. So, just a word of caution, definitely probably use something outside of the chat platform provided, just to be safe.
And let me add one more comment. In connection with your engagement to help a lawyer during a deposition, in the past, when a lawyer has used an Excel sheet with a witness, you can't really help, right? You don't have a copy of it running in front of you. But in this new world, the Excel sheet should be distributed either through a chat or through an email, and that can be sent to you. And you can be replicating or following along the questioning. And if there is a situation like Sam mentioned, they're looking at column K and it should be column Q, you can immediately be communicating that to the lawyer, and he can be adding it to his redirect or whatever it might be. But that is something which is new. A new feature is that as you're observing a deposition, you can get a real live soft copy of a native file, and you could be following along and preparing the questions to correct any misleading testimony. It is very effective just to be able to get the lawyer to say, well, Mr. Opponent, had you make this change in column K and asked you about the results? Well, if that had an effect on column Z and Q and L, how would you deal with that? And obviously, you talk with your witness on a break about what the impact of it is. But that's a real advantage you have helping the lawyers, is you can get real copies of these documents and you can be working on them at the same time, whereas it's a little bit more difficult to do that in a traditional setting.
I'm sorry.
Just to add something, and all of us on this conference are CPAs, and we've all done a lot of work in Excel. And there are situations in Excel where you can make a change in one cell and it doesn't quite flow through right to an entire workbook. And you'll get a whole list of error messages. And this can be, I would imagine, devastating for you as an attorney if it's your witness. Can Sam and David sort of comment on what's going to happen in that world where the model looks like it's broken just because there's some cell? I can get errors if I don't link. If I've got a workbook, without getting too technical here, I can link a bunch of sheets together, but mislinking one sheet to the rest of the workbook, and one change causes an error all throughout the summary page of the model. So what's your advice to the CPAs on this call on how to deal with that issue?
Well, I would take the offensive. If you're being deposed and the examining attorney is asking you to make changes live in a workbook, I would preface my answer would be, all right, well, I'll do whatever you want me to do. However, I want you to understand that this is a very complicated Excel spreadsheet with interlinked formulas. So if you ask me to change something, it may make the whole thing screw up. I can't control that. It's not my opinion anyway, but if that's what you want to do, I'll do whatever you want me to do, right? And then just make it clear in your answer that it's the attorney's fault. He's also someone who clearly doesn't know Excel as much as you do, right? And is not an expert, and is about to demonstrate his ineptitude. And I would just be affirmative in sort of bolstering your own quality of work by saying, well, I've done a really good job here, at least implicitly. By the way, this, notice the room turned off on me because I did not turn the automatic light saving switch off. So now I'm in the dark. It's another example of something you want to be mindful of. Let me stand up and do this. Do the turn off. Yeah.
Well, Sam's getting the light back on. You guys might think we staged all this. We didn't. These are just things that happen to show you what you need to do to prepare. But I think Sam's answer is dead on, and it's kind of what I hinted at before, which is I can make whatever change you want to this model, but that is not my opinion. I would need time. We took, as Alex mentioned, countless hours with the inputs and making sure that with the information we were putting in, this was all running right. So when you start making changes to it, it has an impact, but I can't tell you whether that is going to be reflective, whether your change is going to be relevant or probative of anything in this matter. I need to study it. But yes, if we do change that number from 5 to 3, the spreadsheet kicks out this result. But I'm not telling you that means anything. I mean, I just think you need to be very clear about what you're owning and what you're not owning. And remember, the cardinal rule of a deposition is there's no harm in giving the lawyer something that they already had when they walked in the room. And they already had the ability to change that number from 5 to 3 and see what the result was going to be. So when they do it and it spits out a number and you say, yes, that's what happens. When you change that number, that's the result. All you can do as a witness to guard your ground is say, it does make, that is the result from the spreadsheet, but I can't tell you sitting here without taking the time I did with my original model, whether that means anything or not.
Okay, so that's good advice. I mean, this is all stuff that I think most of us who are on this call probably haven't thought about. And we need to think about it before we go into that deposition or that trial testimony or that proceeding. And one of the things that that comes to mind, you've covered all the unexpecteds, like the lights going off and the technology type issues. But what about the fact now you've got a witness who has their computer with their documents on it, and either the witness, the opposing witness, from whoever, starts trying to go in and pull up documents that you didn't know about as the attorney, or were maybe provided to the other side, but nobody really focused on them. How do you deal with that?
Well, a couple of things come to mind. First of all, we tell witnesses, don't bring anything to the deposition unless you're going to, your expert report, your support binder, right? That's typically what experts come in with. But don't bring your computer, don't bring the model live. And Larry, you're exactly right. The difference now is you're sitting at home, and if the other lawyer says, well, you have your laptop with you, why don't you pull up the model? Or why don't you pull up this sheet? Or why don't you give me the contact information for this witness that's identified in your report that you talked to? Get me their phone number. You got your phone, you're sitting there, give it to me. And you really need to do one of two things. One is rely on the lawyer who's presenting you to handle that and say, there's no subpoena ducis tecum here for documents for this production. It's not appropriate. The witness is here to answer your questions. If you wanted to get access to what's on his computer, you should have served notice to that, and we would have been able to produce them. Or when you set up your conference, have a different machine. Now I've got a different, I'm using my iPad. It doesn't have that stuff on it. I mean, that's in the other room or that's at my office, and I'm not prepared to do that. Those are the two ways that strike me, Larry, as you can deal with it. Again, this is also something, though, that in these kind of stipulations or agreements that the lawyers enter into before, they should proactively address. And you should be, as the witness testifying, you should know whether or not that's fair game or not. And the lawyers, so bring it up with the lawyers and say, I mean, it's a great point. How are you going to deal with this? Is there an agreement in place with the other side about what I have to show them from my personal computer? Because if not, I may go get a different machine to use, because I don't want all my personal information being subject to discovery.
Yeah. Oh, go ahead. I'm sorry.
Jumping off of back to this, the negotiated protocol. I'm curious about this a bit. I know you mentioned one thing there. Like, what other items is typically negotiated between counsel in terms of depositions that might show up in this document that you're referring to?
Well, so one of the things that's hotly contested or not contested, but negotiated is exhibits. And so what you'll see in that sample, I think I provided this sample standing form order from the Southern District of New York, and then there's one that was entered in the Eastern District of Texas that's on a live order in a case. And it's how to handle exhibits. And so, I've found that, people defending witnesses have this fetishization for paper documents. And I've spent a lot of time talking to counsel over various cases about, I want you to send me a copy of these exhibits ahead of time. I'm like, well, I'm not really going to show you my work product. Okay, well, I'll keep them in a sealed envelope, and we'll go through this kabuki theater where I'll hold up the envelope and show you I only open it when the witness has it. So that's something that gets talked about a lot, right? Do you send exhibits ahead of time? If you send exhibits ahead of time, how are they secured? That's a very common issue. And so for expert testimony, right, I mean, one of the things you want to talk about is, okay, well, if you're going to show my witness live spreadsheets, you need to tell me, because I need to make sure that he or she has access to the ability to look at that. I'll give you an example. I have a case where I was the plaintiff, the defendant wanted to use a service where you drop the document into the chat in a sort of a modified Zoom. However, it did not allow you to open up Excel and run the file. And so, they were trying to examine the witness with this Excel spreadsheet. It wouldn't open. And, there was all this consternation. And I was like, it's not my problem. I mean, I don't know what to tell you. I mean, you should have thought of that ahead of time. So these are some things that really or exhibits are probably the biggest issue. The other thing is conduct during the deposition and communications with whom during the deposition and at breaks. Now, I was a little bit surprised at in my experience. So there's no question the rules of ethics and the rules of civil procedure apply remotely or not. So it's not as if we're going to do this remotely and suddenly all these things I could never have done in person, I'm allowed to do. And so when we first started this, I guess naively, my attitude in dealing with opposing counsel was, well, I don't know why we need to have like a separate order about our, what witnesses can and can't do during a deposition, because the rules set that forth pretty clearly. And apparently, I guess there's lots of people out there that are like cheating or want to cheat or something. I don't know, because they wanted to talk about every little thing. You can't have a cell phone. You can't text. You can't email. And in my mind, that's just a given. You're not supposed to behave in a way that's unethically. It's not unethical. But that's commonly put in particularly these federal court stipulated orders where you discuss, what witnesses can and can't do. Now, expert and fact witnesses have different may have different rules. So, in Texas state court, lawyer communications with an expert are not privileged and are, discoverable. Federal court has a different analysis. And then, of course, lawyers can agree to handle things differently in an individual case, right? Or the court may order something in an individual case. And so getting clear with your attorney about what you can do, what you do, if it's discoverable or not, knowing that ahead of time is going to be important, because the last thing you want to do is have sort of inadvertently communicated with counsel or said something during a deposition, and then suddenly you got a big fight about whether that was proper or not. That's something you definitely want to talk about with your lawyer, and hopefully has been sort of discussed amongst the two sides, so that there isn't any gray area and there aren't going to be any fights later.
I'm not going to add anything substantive. I think Sam covered it all, but I do think it's important, and Alex raises the point, that you as the witness, you ask for that agreement. You want to see what the protocol is so you know what to expect. If you have a right to have a copy of an Excel that you can open, you need to know that, so that when they try and chat it to you and it doesn't open, you can say, I'm supposed to have the right copy. I'm not going to answer, and a lawyer will jump in too. I'm not going to answer questions about this because there's a protocol on this and you're not following it. You need to know what to expect. The depositions I've done, we've had a couple of kind of informal agreements and stipulations, but we have not provided the exhibits in advance. And I think that's an advantage for the questioning lawyer. I mean, Larry, I may be jumping ahead, but the conventional wisdom back in March was that Zoom depositions and Zoom testimony, 100% of the time, advantage witness. And I'm not convinced that's true. I think there are a lot of situations, depending on the witness, the topic, how intensive the documents and exhibits are, that it's advantage examining lawyer. And exhibits is one example. And if the witness doesn't know what to expect, that's another example.
So Sam, one thing you brought up was different jurisdictional rules. You have your federal rules versus Texas rules. And coming back to helping, how CPAs help attorneys during depositions, or you're taking the opposing expert's deposition. Now, I used to be sitting there next to you in the room, and I could, write something down on a sticky note and pass it to you. And, now I'm having to either, send a text message or email you, or, do a phone call. Is there, in terms of, the email and text message, is there a concern from a discoverability standpoint on that type of thing?
Yeah, there could be. I mean, I've been known to be difficult sometimes in depositions, and in Texas state court, I've seen that happen, and I've told the lawyer, it's like, give me those notes. I want to see them. I want to look at them right now. Your communications aren't privileged. I'd like to look at those. And the rules are different in federal court, and then they can be different by stipulation. So, the fact that you're doing it, whatever the communication is or the medium that you're using, doesn't affect the rule. And so I think it's what you need to do is have a conversation with your attorney ahead of time about, how can I help you? Okay. And then, is this going to be, and then ask them, is this going to be discoverable or not? I mean, they're the lawyer, they're supposed to know. And then, you won't get surprised on the back end, but, that's kind of the rules. It goes back to what we talked about at the beginning. The rules have always contemplated remote depositions. There's not a separate set of ethical or procedural rules for remote depositions that exempt someone from behaving, properly, or being bound by whatever they're being bound by. And the medium doesn't change those obligations. I guess some people may think it does, but it most certainly does not.
Yeah, and that's exactly right. When you have sticky notes or notes on pads, you can make a demand at the time to see them. The lawyer may or may not let you do it. Right. And then who knows when you actually get those documents, whether you got what was actually being used at the deposition. With the electronic communications, they're time stamped, right? And they're preserved, and they're there forever. So there certainly is a much more certainty about what was and wasn't communicated at the time. But Sam's got it exactly right. Substantively, the rules are the same. And the problem is that there's a little bit of distrust, but when you're sitting in a deposition room, the lawyer on the other side is not going to do something that's going to violate the rules, because you're sitting there watching him. He's not going to hold up a notepad and says, the answer is yes, because you're there and you'll see it. And the concern is that when you can't see it, because it's a remote deposition, it could happen. And so these stipulations, these agreements really are a little bit out of a sense of mistrust, maybe even paranoia. But we hear stories. I mean, I heard a story about a witness testifying in a room, and there was audibly a squeaking noise, like somebody was writing on a whiteboard, right? That is a way in which you can communicate to a witness who's testifying, and it was off camera. And that was just a story. I heard it third hand, but that you try and eliminate those kinds of risks with these stipulations. It's never going to be perfect, but the reality is, I've seen it. I know Sam's seen it. Perhaps anyone who's given a deposition has seen a lawyer do something live in a deposition where he said, that's coaching the witness. You're not supposed to do that. Or what's that note you just passed the witness? And that's when you're there watching them. And so when you can't see them, there's a sense perhaps that maybe someone might do something and it might be innocent. Maybe you're nodding your head or shaking your head along with the witness, and the lawyer asks you on the other side, stop doing that. When you nod your head, you're suggesting an answer. I've actually had lawyers say that to me, and I wasn't even aware I was doing it. But when you can do it with impunity and feel you're not going to get caught, it causes some concern. And of course, you guys as testifiers, you do not want to be engaged in any of that. You do not want to have a lawyer telling you what the answer is you got your own ethical obligations. But at the end of the day, the testimony needs to be yours. And that's what we always tell our witnesses is I'm not testifying for you. I can help you with breaks. I can give you, if you have a question about the facts of the case, I can give that to you. But at the end of the day, the opinion's yours and you got to defend it.
So you brought up something, David, that is a bit sensitive in terms of, we all have personal traits. We all have our body language. We all have drainage in our throats sometimes, and that sort of thing. Is the new world of testifying via Zoom, does that cause people to need to be more aware of their personal traits, of what can be seen on the screen, not just in the background? But in a deposition in a formal room, people are usually pretty formal. In a courtroom, they're real formal. But now we're at home or we're in our office. Can you tell us about what your view of that is in preparing a witness?
It is a new world. And whereas you would be used to, as you said, the reminders of the formality and the sobriety of the situation, because of your surroundings, you don't have that anymore. And your audience similarly is watching a video game, like they're watching a movie, right? It's not there's a real interaction going on, even though what's happening may be live. If it's a live Zoom presentation, to them it's all, if they're looking at a screen, it might as well be a recorded deposition or a movie, right? They're not participating, they're just watching, and they're not seeing it live. It's not a play, it's a video. So you got to be aware of that. I do think on the self-awareness, you have a little bit of an advantage with Zoom. I'm looking into this camera right now, but I can see myself on the screen behind the camera. And that is something which I wouldn't ordinarily be able to do. If I can see that I've got, a piece of my lunch hanging off my face, I can wipe it off. But I don't think, at least. But there's a little bit of an advantage in getting to see yourself testify or see yourself in a meeting or see how someone's doing. But I think you're exactly right that you might let your guard down because you're not reminded of where you are virtually in a courtroom, giving live testimony. So I think it's a good point. I would recommend that, again, just tips, that you make sure your setup is such that you can be watching yourself while you're testifying, in addition to, whoever's asking you questions, hopefully the jury, if the jury's there. But remember, if you get a camera of a jury, your setup may be that you see, 8 people spread out on one camera shot, and you can't really see their faces or how they're reacting to you. And it really is a disadvantage, if you're sitting in a witness box 10 feet from 12 people sitting right next to each other, you can see if someone is not understanding what you're saying. You can see if they're shaking their head or they look confused or they want to ask a question. You can stop and slow down and react to that. Very difficult, in my opinion, to do that in this new world if you're doing it by Zoom.
And I'll add, I think everything David said is exactly spot on. And one thing I would note is just remember, keep in mind, for expert video deposition, right, it's almost 99% of the time, the only time that clip is going to get played is for impeachment, right? So you're almost assuredly going to be live at trial. And so you'll give live testimony, and so the transcript will, be useful. The transcript and the video are not going to be played except for impeachment. And so, you should keep that in mind, right? Like, how am I presenting? How is this? You didn't have a whole lot of, you had very little control in a live deposition or an in-person deposition, I should say, because the videographer set up the background, the videographer set up the angle, the zoom, all of that, right? That you had no control over that, and lawyers have even, just a little bit more possibly. But you have an extraordinary amount of control over your own camera in your home office or your work or wherever you're giving the presentation. And so background, all this other kind of stuff matters. But like, how far away from the camera are you? These kinds of things. And so that, again, kind of dry running this with the attorney ahead of time is useful. I mean, if someone's using a service, then the service every service we've used, they'll reach out and say, we'd like to test your bandwidth. We'd like to, schedule a time to do this, or here's a link to see. You can see what all of it's going to look like, when it's live. And you want to be obviously a witness that presents the best that you can, because, when the video is going to be shown, it's only going to be shown in a way that's designed to hurt you. And so you don't want your visual presentation to contribute to that if you can help it.
So those are incredibly valuable tips. I mean, it is so different to be in a formal setting versus an informal setting. And if you're at home having your dog bark, or the UPS guy ring the doorbell or something of that sort, that those kind of things are going to happen at home, that you're just not going to have if you're going to be in a conference room somewhere. So which brings me to the next question that I was hoping that you all could address, and it may be somewhat premature, but we've talked a lot about depositions. What about actual trials? How do you see Zoom playing in the courtroom in terms of an actual trial? Are trials going to be virtual? How is the judge going to handle that? Have you seen it yet? Sam, have you seen that yet?
Well, no. There was too much fanfare. The quote unquote jury trial in Collin County a few months ago, back in August, I think. But it wasn't sort of a jury trial in the sense that the jury it was an advisory trial, right? And so the jury's verdict was not binding and then formed into a judgment later that bound the parties. And I don't know if David, I've not heard of a full and complete remote trial where the jurors are remote in Texas. David, I don't know. Have you?
There was one, and it was a test case. It was in Travis County.
Okay.
It was a speeding ticket or in a construction zone, and it was a younger judge who was keen to try out the technology. I'm sure there were agreements in place because after the jury found the defendant guilty, there was a very lenient sentence. From what I hear afterwards, there was a jury consultant who was engaged. This is on a $200 or $300 fine. So I think a lot of people were getting experience on that, probably donating their time. And it was kind of cool to have it be the first one. But it wasn't one of these big civil cases with an expert. They had someone, I think it was a police officer, testified about the technical aspects of whatever the radar gun or laser gun was for time. But we are going to start seeing it. I think, I've got an evidentiary hearing that's going to be by Zoom, next week. And, I think in certain parts of the country, it's going to become more common. I know the Dallas courts are opening up for jury trials next month. I know there've been a couple live trials in various federal courts, and they're taking it very seriously. But I do think that for example, Los Angeles and Chicago, where I've got a couple of matters going, we're going to see them by Zoom. It's going to be the preference. I've got a matter in LA. In every appearance we have now, we get a notice that says the court strongly prefers to conduct these proceedings by Zoom. And there was even one where there was a trial setting notice where we're going to have to go in for a conference, and they said preference will be given to those who participate in this proceeding by Zoom. They are going to be pushing us to do it. And if you think about a lot of the matters that involve economic damages that you guys are engaged in, they're bigger cases, and there's going to be geographies involved where people are going to be traveling, and we don't want to have. I candidly told my judge in one of these cases, do you really want me going to DFW, getting on a plane, flying into Midway or O'Hare, right, and then bringing whatever I've seen into your courtroom? Same with, lawyers, we've got an appeal up in New York, and they were doing the oral argument was by Zoom, and they don't want lawyers coming in from Chicago and Dallas and California for an appeal when they don't have to, and can do it effectively. So I think there's going to be a push in some places to open up live jury trials, but I think a lot of it's going to be by Zoom, especially arbitrations. I think arbitrators are going to be pushing to use that. I know there's been a number of arbitrations by Zoom already. And if you're an arbitrator, you love it because at the end of the day, it's easier for you. You get to stay at your house. And for better or for worse, the arbitrators we pick are going to tend to be in a higher risk age than some of the judges that we're going to see who may be younger on some of these state court benches. And they're going to want to be a little bit more protective of what they're exposed to. So I think it's coming.
I think I couldn't agree with you more. And I'll say, even if at the end of the day you've got a jury trial in person and it's going to be postponed or it's going to be held, there's been some live trials in the Northern District. The Eastern District is having live trials. Dallas County is about to open up. Other evidentiary hearings where there's no jury and it's just the judge, like a Daubert challenge or Robinson challenge in state court, I think you should assume those are going to be for the foreseeable future by Zoom. And I've done one evidentiary hearing by Zoom. It was an experience, and I'll do it differently the next time I have one. But those are definitely coming, right? I mean, you're definitely going to be giving testimony in remotely in legal proceedings before the court, I believe.
So I want to jump in and comment on the actual live trials via Zoom or some equivalent. I teach in the graduate school at SMU. I teach a course in forensic accounting. And what SMU is doing for their classrooms is they're putting cameras, one on the professor that's doing the teaching, but another camera on the audience, on the students. So when a student asks a question, the camera can pick up that person's question and they can see the person. Do you see a time when the courtrooms become equipped, so where you'll have the judge and the jury, and that's it, and you'll have the cameras, and you'll have the cameras facing the jury, the cameras facing the judge, and the cameras on the testifying witness? Do you see that taking place, or is that going to be challenged as unfair in some way, shape, or form?
So remember, trials are open proceedings. Anyone can go in unless the courtroom's been closed because of some confidential or proprietary testimony, some kind of secret is being discussed. Anyone can go in and watch a trial. So, for example, the trial I told you about in Travis County, that was on YouTube. It was being broadcast live. I think that is coming. I think actually that's been done, Larry, believe it or not, that the courts have said, I'm going to kind of take a middle ground. I'm not going to expose everyone to each other, but I think that the lawyers ought to be able to argue live in front of the jury, and I think that the witnesses can testify by Zoom. So we're going to have, instead of 30 or 40 people in the room, we're going to have the same 12 or 15 people in the room for the trial and space them out. But yeah, I think that's not only possible, I think it's been happening, and I think that if someone wants to claim that it's unfair that their trial is being broadcast live, the cameras in the courtroom issue is not new. I mean, we had that with the O.J. Simpson trial. Everyone remembers was broadcast live. There's got to be a real legitimate reason to shut down access to the courts. And we as lawyers, when we're young lawyers, our seniors always said, go down to the courthouse and watch some trials, watch some motions being argued, go get some experience seeing what happens in the courtroom. So, and the press obviously has access to the courtroom as well. So you can't keep them out. And if you're going to be able to stream a trial, the press can pick up on it that way. Having said all that, if that becomes the new norm, it makes it much easier to monitor lots and lots of trials because you don't actually have to go down to the courthouse. And one person can potentially record what's going on in 5 or 6 or 7 different courts all around the country, and review them, fast forward through them, and get information. So it's a different kind of it's just more information that's going to be going out across the web.
And I would say it's not only trials, but here in Harris County, they're recording, the evidentiary hearings and a variety of hearings. Basically, if it's open, if it was open to the public pre-COVID, there's a live video feed for the same thing nowadays. It's just a link on the Harris County clerk's website. Anyone can go and click on it. And I'm sure that's probably true for a lot of jurisdictions.
Do you all see any rule changes that witnesses such as CPAs need to be made aware of, or pending rule changes, or changes that are occurring to the rules in other states that you think might migrate to Texas?
Well, honestly, I'm not aware of any pending rule changes, though I confess I have not come through, any proposed changes. The way this has been handled, I think universally, has been by court order. So state Supreme Court, like Texas, for example, other state Supreme Courts, and then local rules promulgated, or standing orders promulgated by federal district courts have been the way this has sort of been handled. And so the adjustments to procedure or process, rule suspension, rule modification, has all been the product of court order, at least in my experience, and may change. Supreme Court orders have had, the ones that have been issued, it had, deadlines, expiration deadlines, and the court would promulgate an extension of it. And it was sort of like self-sundowning is the way the court had been crafting those. So right now, I think it's all sort of an emergency approach done by order. I guess I don't know if David has any insight into this. I think maybe the rules, it may ultimately impact the rules. I'm just not aware of any pending rule change right now.
Yeah, I think that's right. I think we may see some tweaks to kind of just recognize what's been going on, but I'm not aware of any massive overhaul. And again, as Sam said at the very beginning, remember, this isn't new. I mean, the rules provide for this. And I think as a practical matter, what the substance of the work that you do as CPA experts doesn't change. This is simply a matter of what's discoverable. How do we prepare to present this in the most effective way? Am I aware of all of the things, the risks that there could be by testifying in this new environment? Do I need to be concerned about, bandwidth and backgrounds, and, making sure that the psychological factors of not having, an audience feedback and being able to see who I'm talking to, that you prepare for that. But substantively and legally, procedurally, as Sam was talking about, I don't think we're going to see it be much different than what it is now.
Do you foresee a time in the near future where the CPA, the attorneys, I've been in depositions where the attorneys get into kind of massive fights. And do you see that going away because it's all going to be on camera? How do you see that playing out?
Well, I don't know that. So for video depositions, those fights are all recorded anyway, and there's obviously a record of it. I don't know about Sam's experience, but the depositions I've taken have actually had less of that, Larry, than in the past.
Because of the recording?
Not because of the recording, because I just think it's not as effective. You're not going to bully some lawyer into giving up on a question if you're just in the corner of their screen, or you're not going to, the big statement that you're making isn't going to have the same effect because you're not in the same room. A lot of the grandstanding that, in my view, that lawyers do at depositions is kind of posturing and trying to either intimidate a witness or intimidate the lawyer on the other side. And I just don't think it works as effectively remotely. And that is part of why the conventional wisdom when Zoom depositions came around was advantage witness, right? It's harder to intimidate a witness on Zoom. So I don't know what the reason is. And maybe I don't have enough of a sample size because it's only been 7 months, but I haven't seen as much of that as I would see in a live deposition. And it might be that it's harder for someone to get worked up about what's going on. The lawyer who might otherwise engage in that, pick that fight. It's harder to get worked up when they're sitting in their home watching a deposition on a screen. Whereas, the blood may really be flowing in the deposition room when in the heat of battle, and you don't feel as you're in the heat of battle as much when you're on Zoom.
Sam, what about your experience in this?
Yeah, it's very similar. I mean, the recording aspect of it, it's always been the case. And in most of the deposition or all of the depositions I've done, counsel's not recorded. It's just the witness, and then the counsel has, objections, and then obviously the questions are being recorded. The oral component of it is, but not the video. And so, I agree with David. I mean, it does the sort of like posturing, brushing people off the plate kind of, schoolyard antics lawyers engage in sometimes seems to be minimized. And when people have tried it or engaged in it, it is sort of falls kind of flat. I mean, it's hard for a witness to take, to be browbeaten, so to speak, when they're 3,000 miles away, right? And you're on a screen. It's very different being in person. And so I think that aspect of it, it remains. And I think David's exactly right. The relative perception of advantages has been upended to some degree. I think people can see that many depositions can appropriately and effectively be taken remotely, and it's certainly far less expensive and more efficient, and provides a lot of opportunities for like in-house counsel to see depositions or parties to see depositions when they just can click on a screen and really drop in or out. Frankly, they don't have to commit to an entire day in a conference room. I do think, however, as someone who, I'm going to tell myself is perhaps engaged in some, quote unquote grandstanding at times in a deposition. I mean, I think that a very important witness, a key witness, particularly one that may be evasive or obstructionist, there is going to be a preference, I think, for those kinds of folks to do it live. And, if and when the normal becomes normal again, I think we'll see a lot more Zoom depositions, and I think experts are a perfect example of why a remote deposition is appropriate, particularly if they're out of jurisdiction, because it's an expert deposition, not a fact deposition. But I think key witnesses are still going to be wanted. People are going to want to take them live if they can.
So we're I know we're going to lose Sam here in a couple of minutes, but can you all comment on, so typically after the deposition's done, a couple of weeks go by and the expert gets a transcript to review and to make changes in quotes. How is that going to be affected by the live recording of the entire proceeding now? Will witnesses still get a chance to look at the written transcript and make a change, or how will that change?
I don't think it changes at all. The rules still apply. The sign and return deadlines and rules. None of that's changed. And
what can the witness change? What now that it's all recorded? What exactly can the witness change? Is the witness going to have access to the recording to be able to? It really hasn't changed because if the lawyer always could video the deposition. Typically, I video all my depositions unless there's some reason not to, and including expert depositions. So, and what was returned to the expert is not the video, which cannot be changed by the witness, but the transcript. And then the transcript is reviewed, and there are any errata items. Those errata sheets. Errata sheet is added and then returned to the attorney and certified, as sworn by the witness. Right. So none of those rules have changed, and Zoom doesn't. The remote nature of the deposition doesn't have any effect on that, unless David, unless you have a different view. But I think it's exactly the same.
That's exactly right. Whatever your practice was before, some witnesses read and never sign. Some read and make changes. That's a preference that witnesses have, and certainly lawyers have. My view has always been you never change a transcript unless there's something that you can't possibly deal with at trial. It's hard to say, I said the light was green. What I meant was it was red. That's hard. That's a hard one to fix. But I said million. I should have said billion. That's just a misspeaking, and you can deal with those kinds of errors. But I agree with Sam. It's I don't think there's any impact on reviewing transcripts.
So from a legal aspect, which is the official legal record, the transcript or the recording?
The transcript. The transcript is what you use to impeach, but you can play the recording, right? And you can put the errata in and get the witness to say, you originally answered this, and then you changed it after the fact to yes from no. I mean, you can do that, but the original, the transcript that as corrected is the official transcript.
So Sam, at this point, I think we're going to say thank you very much.
Yes.
And I appreciate your being here. The Zoom, this session will go on for the next 15 minutes, but we will miss you.
Thank you so much. It was a real pleasure. I appreciate the opportunity to speak, and I hope it's been useful to your audience.
Absolutely. And thank you for the documents too.
Absolutely. Thank you.
All right. So for David and Alex, next series of topics, if you will, are really what's the future. I'm going to ask you to put your looking glass or your crystal ball or whatever in front of you and tell us what the future holds. Are we going to go back to normal, old normal, or is this done? This is the new normal.
My view is it's going to be in the middle area. The answer, are we going back to the old normal? I think there's no way we're going back to the old normal. I think that the barriers to Zoom testimony have been torn down and are not going to be rebuilt. The people like me who've been practicing for a long time and thought that this was, a fancy toy, but it's not for me. I think too many of us have been converted to realize there's a lot of efficiency and cost savings. You can do a lot more in a lot less time using Zoom. Is it going to be used as extensively as it's being used now? I think the answer to that's got to be no, because pretty much it's all that's being used now for depositions. So I think there's still going to be, as Sam mentioned, certain witnesses that you're going to want to take live, and if there's not travel involved, then maybe there'll be some live depositions as we emerge, hopefully soon, but as we emerge eventually from the pandemic. But the example I give is this case I've told you about several times in Chicago. I'd have a 15-minute hearing, and in the old world, the judge required us to attend. So I'd get on a plane, I'd fly to Chicago, I'd go to a hotel, stay overnight, get up, travel downtown, go through security at the courthouse, wait for 30 minutes for the judge to come in, have my 15-minute hearing, and then come back. And it killed an entire day, if not a day and a half. Now it's a 15 to 20-minute event. The judge comes on Zoom live at the right time. We have our hearing, and I click off. I mean, that's just an incredibly efficient way to deal with this. And I think barriers for judges have been torn down the same way they've been torn down for practitioners.
Yeah, and I guess to add to that, there's definitely sort of been a sort of a proof of concept that's taken place. And where I see this, I'm working on a fairly large litigation right now, where we're taking the attorneys are taking close to 30 depositions scattered, not only here in the U.S. but also over in Europe. And before the attorneys would have hopped on a plane and flown over, but there's a bunch of travel restrictions and it just doesn't make sense. But in the current climate, but they're now taking those depositions by Zoom. Or another online application, and it's made it easier to schedule those depositions. There's been less of a delay in the case because of that. So that's one perk through this entire process. The other that I've noticed is it's become a little bit easier for we as practitioners to be able to view the live testimony. I'm thinking back, a couple of years ago, I may have, instead of traveling to be at a deposition in person, I may have a live feed from that the transcriptionist is putting together. That those aren't always the easiest to read. For those of y'all that done it know that it doesn't always come across as very clear. And now I'm getting a live feed, a video feed. Or I'm linked in to the audio just because they already have the Zoom set up, or they have something set up and I can just feed into it. The other side may not know I'm there, just depending on if counsel announces that, that I'm there or not. But I'm able to really help my clients out much more efficiently because, I may not be sitting there, but I at least am listening to the live feed or at the video. I'm not, just reading the transcript off of a live stream. So I think there's definitely benefits that we as practitioners can that this is allowing us to provide that, whereas we may not have been able to before just because of travel expenses or other items that were out there.
So we've got a question, David, come in, and this is an interesting question. Now we got this ability because an expert is sitting there, and you touched on this previously, with a computer, and you can get dumped on, the other side can dump documents at you at a deposition. It certainly happened to me before, where I walk in the deposition, all of a sudden I get a new version of the damage model from the other side, for example. How does this change this? I mean, now the expert can look at this, can the opposing side can refer to it. How do you deal with this?
Well, I think you deal with it the same way you did before. It's either something that you're comfortable doing on the fly or something you're not. And if you're not comfortable doing it on the fly, you simply say, this is not an exercise that I can do real time. These models are tremendously complex. I could answer the questions you have, but you need to give me a couple of days to look at this. And my understanding is that's not the purpose of why I'm here. I'll hit whatever keystrokes you want, but if you want me to opine on something that I haven't had a chance to study and to see how all the interconnected formulas and sheets work, I'm not going to be able to do that. I mean, that's one approach. The other approach is if it's not that complex, or if in preparation you've anticipated that the lawyer on the other side might do something like this, and you've got good, you can on the fly answer the questions and diffuse the questioning. In my mind, that would be preferable. If you're confident enough and you're fluent enough with the model that you can explain why what they're trying to do doesn't result in what they think it does, I would prefer for you to do that. But if you're not confident and fluent, I would take the step back and say, we can hit whatever keystrokes you want, but I'm just not going to be in a position to opine that this result means what you say it does, because there's a process I go through in coming up with my opinions. And as Alex has said, we spent countless hours looking at inputs and how they interact. I haven't had a chance to do that with what you've just sent to me a few minutes ago. I mean, those are the two approaches I would take. I certainly would not want a witness to dive into an Excel and start opining off the cuff unless they've prepared to do it in advance and have anticipated the line of questioning.
So what about taking this question one step further? What about a situation where a new document is put in front of you as a witness and says, would this change your opinion?
Same.
It's has not been produced before.
It's the same answer, right? It's if you need time to digest the new information, I would just say I need time to digest it. If you are able to look at it and say, this doesn't change my opinion one iota, and here are the 5 reasons, and you are comfortable that you're right, that obviously is a better response. But if it's oh my God, yes, this document makes me think everything I just told you was wrong. I mean, if that's true, then you got to give that answer. But if you're not sure and you need more time to study it, I would go with, I need to digest this. I need to understand more about this document that I'm seeing for the first time. So
another sort of a question for you. You and Sam are pretty tuned into this world, the technology world, and the Zoom world, and the remote world. How do we as CPAs, what do we need to do to help our clients who might not be so technologically savvy as you and Sam in this new world?
Well, thanks. I don't consider myself technologically savvy. I've learned how to use these tools that, quite frankly, I don't know that I'd even done a Zoom before March of this year. And now, if you count Zoom and Skype and Teams, I'm on probably 10 of those calls a week now. What we used to do by teleconference, we're all doing by video conference now. So we're all becoming fluent with it. I would tell your clients that if they're not using Zoom or some similar technology, Teams or Skype or WebEx, whatever it might be, that they should be, that they need to become fluent with it. And they need to, and you can facilitate that by, you're not having live meetings with them, I assume now. Have a Zoom meeting, and demonstrate to them how you can use the share screen functions and the chat functions to share materials and make it as close to a live meeting as you can. And that's probably more business advice, Larry, than legal advice. But it is something that lets you keep close to your clients in this new environment, at least as close as you can, because you're not going to be able to have as many lunch meetings, and the happy hours are going to be a little bit more restricted and all that kind of stuff. So my advice would be that become fluent with the technology, try and break down the barriers in your own practices, so that when you confront it in my world, in the legal world, it's not foreign to you.
Are you willing, this may put you on the spot, but are you willing to say that there are some of these tools that you should stay away from? You mentioned several. Are there ones that are particularly user unfriendly?
No, there are security issues that you got to get comfortable with various ones. For my skill set, I do have a preference for one over the other, but that doesn't mean that it's better. And your organization will probably have a preference. There are some that are more ubiquitous, like Zoom. Everyone knows how to do Zoom, who knows how to use these virtual platforms. So it's easier for them if they've never used Teams before, or you're using Skype for Business. There's sometimes they have to go in and download software. But when you set one of these things up, you just want to make sure that the audience or the recipients of your invites have the technology. And I just typically ask, what do you like to use? And then I become flexible.
Yeah, I think that one of the themes in all this is planning is key. There's an expectation from judges that people are going to be familiar with the platform. I had the privilege of listening to Judge Garrison and Judge Sandel down here in Harris County earlier this week, and they said, during evidentiary hearings, one of the most frustrating things they see is when they have a witness that, they basically have to waste 5-10 minutes trying to figure out how to work the platform, or they run into issues. So I think, making sure we as witnesses are familiar with the platform and comfortable with it will go a long way, especially if you're testifying in a trial or a hearing. The last thing you want is to step off with a bad foot with a judge. That never ends well for anyone.
And it's jumping off what Alex just said, if you're testifying as an expert at a deposition and you are familiar with the platform, and you can say to the lawyer, look, can you just give me control and let me share my screen with you and show you something? That's a very aggressive tack to take, and the lawyers may not want you to do it. But having that in your quiver, having that arrow in your quiver is important. If you're testifying, you say, well, I could explain it to you if I could just show you this document, but I don't know how to do it. Right? That is never something you want to say. You don't want a jury to hear that you don't know how to work the technology. You want to be an expert in all things, and people expect accountants and damages experts and technical experts, everyone at least know how to use a computer. You're telling me you can manage this, Excel spreadsheet with 50 different notebooks, but you can't share a document on Zoom. I mean, you don't want to be in that position. So I think Alex is exactly right. Know the platform, know what you can do. Doesn't say you have to use all the features, but you should be prepared to.
Great advice. Great advice. So we're about to the end of our allotted time. Alex, do you want to say a few words as the leader of the Business Valuation Litigation Group at the Texas Society of CPAs?
Yeah, definitely. First off, I know Sam is no longer here, but I want to thank David, for helping out with our first webinar conference. And like I said earlier, the presentation, we're going to have many more of these to come. We're aiming to, hopefully have one every other month. And part of this is due to we weren't able to have the live conference this year, and we wanted to at least make sure we are offering our members the CPE, CLE on some very timely topics. So this month, we have a litigation focus. We're also going to be pulling in some more valuation focused type topics in the future. So definitely more to come. And if anyone has ideas or has a particular topic they would like to see discussed, feel free to reach out to me or anyone on the BBFLS committee or the TXCPA. This is your society, and if you have ideas and topics, pass them along, and we will make sure to see if we can find a way to incorporate that into future presentations.
So with that, David, I want to thank you very much. I guess we're all in this in sort of a new world, and it will be interesting to see where it leads. But I do agree with you; it's probably here to stay. So thanks to everyone for joining us, and hope to see you on our next webcast.